Hello, everybody. Welcome to this week's edition of The Productive Attorney. My name is Jim Zeta. This podcast is designed to make you more productive as an attorney so that when you can be productive in your practice, so then when you go outside your practice, you can do the things that you want to do that are outside of the law. This week, we're talking about a subject that is obviously in the news a lot recently, and that is gun laws. I want to start out by saying that this podcast is not political in any way. I am not taking any political positions one way or the other on the gun laws. This podcast is sensitive to the recent events, and it's current because of the recent events, and so that's why I wanted to talk generally about what gun laws are in Texas, and this is more for educational. I'll let everybody else talk about the politics. I just want to educate people on what the gun laws are in Texas, and when people say, oh, you know, the gun law in Texas says this or says that, I would like people to know what they say generally. There are so many laws regarding firearms and guns in the state of Texas that one podcast could not even come close to touching on all the subjects. And some of them I've just recently done research on to update myself. And if I'm slightly off in this, please send me a comment or send me a note indicating that my statement or interpretation may be slightly off. I'm not intending to affect anybody who's pro or anti-gun or anything like that. I am just trying to tell people generally what the laws are in Texas. And so when you hear people say, oh, the Texas gun laws, at least you have some education and knowledge what you're talking about. Any discussion about gun laws in the state of Texas start with the biggest law that we have, which is the United States Constitution and the Texas Constitution. The United States Constitution, the Second Amendment, the right of the people to keep and bear arms shall not be infringed. Then the Texas Constitution, under Section 23, Article 1, says that every citizen shall have the right to bear arms in the lawful defense of himself or the state, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. I thought that was interesting in that the Constitution actually in Texas anticipated that the Texas legislature could regulate the wearing of arms, which is something that they did in 2021, which we'll get into pretty heavy. If you're looking into federal laws with respect to firearms, the place to go is Section 92 of 18 U.S. United States Code, Chapter 44. That is the Gun Control Act, and it sets out the federal laws with respect to gun control. And we'll talk generally about how those laws apply in the state of Texas as we go forward. One of the things that the federal law requires is that if you are a federally licensed firearms dealer or seller of firearms, you have to do a background check. Now, Texas is not a point of contact for the quick check background check, and so those dealers have to go through the FBI directly in order to do the background checks. However, there is a loophole in Texas. It's called the gun show loophole, and that is private individuals, that is a private seller who does not rely on gun sales as the primary means of income. They can sell guns, and they can sell guns without having to do any background checks at all. So if you go to a gun show and someone sells you a gun in Texas, they can sell you that gun, and if it's not their primary means of income, they do not have to do a background check on you in order for you to get that gun. Texas law is known for a lot of what it doesn't do as much as it does do. So, for example, under Texas law, there is no requirement for a permit or a license to buy a gun. There's no Texas law that says that. There's no requirement in Texas to register a firearm. There is no minimum age in Texas to possess a firearm. There's no assault weapon ban in Texas, and there's no magazine capacity restrictions in the state of Texas. In 2015, the Texas legislature passed a campus carry law that allowed handguns on college campuses and dorms, and that was upheld by the U.S. Fifth Circuit in 2018. Gun retailers and manufacturers, a law was passed in 2021 that allowed them to stay open during a declared disaster time. There was a law passed called the Motorist Protection Act, which allows Texans to carry handguns loaded and within reach within their vehicles, so you can have them in your vehicle. There is no waiting period in the state of Texas to buy a gun. Federal law prohibits handguns to be sold to minors, and they define minors as anyone 18 or anyone under the age of 18. Texas law says that you can't sell handguns. I mean, strike that on the sale of handguns. Federal law says no sale of handguns to anyone under 21. Texas says you can't sell firearms to anyone under the age of 18. So handguns, this is where it gets a little nuanced. Handguns are covered by the federal law, so people under 21 cannot buy handguns in Texas. But long guns, such as rifles and shotguns, they're not regulated by the federal law. They're regulated because the federal law says we're not applying our law to handguns and I mean to long guns and rifles, and so it defers to the state. And in Texas says you can't sell firearms to anyone until they turn 18 unless prohibited by federal law. So they cannot sell handguns to people until they turn 21 because that's prohibited by federal law. But they can sell long guns, rifles, shotguns, AR-15s. They can sell those to people who turn 18. And so in Uvalde, the person who bought the gun, who was the shooter, bought it at 18. He was allowed to, and the federally licensed dealer was allowed to sell that gun under Texas law when that individual turned 18. He was not allowed to buy it before he turned 18, but when he was turned 18, he could have bought those. He was not allowed to buy a handgun. That individual would not have been allowed to buy a handgun until he turned 21. The other major law in Texas that passed recently, very recently, was the Firearm Carry Act of 2021. So previously, in order to carry a firearm, generally speaking, in the state of Texas, you could carry a concealed firearm if you had a license. But that changed with the Firearm Carry Act of 2021. Now it says that Texas residents 21 or over, so we're back to, and this applies to handguns. Texas residents 21 or over do not need a license to carry a handgun if they are not prohibited by state or federal law. And so you go back to the state or federal law with all kinds of restrictions on people who can carry handguns. That goes to your federal law, that goes to your state law. And the restrictions under federal law and state law are what you would think. The restrictions are, look, if you've been convicted of a felony within a certain amount of time, you can't have a handgun. If you have been declared mentally incompetent, you cannot have a handgun. The law says if you're under a protective order for stalking, harassing an intimate partner, you cannot purchase or carry a handgun. There's certain types of assaults that if you've been convicted of, you cannot carry a handgun. So that's people who cannot carry a handgun under the law. But if you don't fall under those exceptions, this act allows anybody in the state of Texas over 21 or over to carry a handgun either concealed or open without any license. As long as you're not one of these people under the exceptions, you can carry it. Now, there are places in Texas where you can't carry it, and I'll get into that in a second. But I just want everybody to understand the general law in Texas is that anybody who has the right to lawfully possess a firearm can openly carry that firearm as long as they don't meet any of those criteria of people who cannot possess a firearm, can openly carry it or conceal carry it anywhere they want in the state of Texas, with the exceptions we'll talk about, without a permit, without a license, without having to register that handgun anywhere. They can just carry it. just as a comment, when this passed in 2021, I thought that we were going to see a lot more people carrying handguns openly. And to the people that I know who previously had concealed handgun permits, I asked them, are you going to be carrying your handgun openly going forward? And every one of them said the same thing. I carry a concealed handgun for my personal protection. And if I'm in a position where the other person who is coming has a gun, I don't want them to know I have a gun because I'm the one that they'll target first. And so I'm going to keep my handgun concealed. And so what I thought would happen when we see a lot of people openly carrying handguns, I'm not seeing it at all. Rarely do I see anyone other than law enforcement openly carrying handguns in the state of Texas. Now, we're still just coming out of COVID, and so I haven't been around, tons and tons of people, but that's been my experience just on the side. So what happens if a police officer comes up to you? What's the law say when a police officer comes to you? And the law is that a police officer can take your gun, whether it's concealed or openly carried, if they reasonably believe it's necessary for their protection, but they have to return the gun if it's determined that you're not a threat or have not committed a crime. So, they have to give it back to you. That's just what the law says. The interesting thing on the open carry is that the open carry, the guns must be holstered. So, you think about the holsters almost from the old-timey westerns where they have the guns at the hips, but in reading literature on this, holster law is not only at the hip. You can have a holster around your ankle. You can have a holster in the small of your back. You can have holsters in all different places, and so the law allows for that. So where is it that you can't have a handgun in the state of Texas? Well, you can't, and they've made the law where you can't have a handgun or a long gun at these places. One is at a school. Now, there's some general laws. There's a gun-free zone law, federal law with respect to schools, and then there's some additional laws in Texas as to schools, and I'll get into those a little bit, but generally speaking, the general rule is you can't have a handgun or a long gun at a school. You can't have it at a polling place, at courts, at a racetrack, at secured areas of an airport, not within 100 feet of an execution site on the day of the execution, which, as an aside, I find that kind of ironic, is that the guns are generally used to protect yourself and they have the ability to kill, but they don't want guns near on the day when they're going to kill somebody. Bars. Now, bars are unique in Texas. This is where there's some reasons, even with this Firearm Protection Act of 2021, there are some reasons still to have a license, and this is one of them. So in a bar, you can't have a handgun or a long gun unless you have a license to carry, in which case you can bring a handgun, a concealed handgun, into a bar, unless the bar has what we call a 51% sign. What a 51% sign means is this establishment makes 51% of their revenue, and I believe it's revenue. I'm not sure if it's revenue or sales, but 51% or more of its revenue or sales is alcohol related. And so if that's the case, that's a bar. In those cases, those bars can put up a sign saying that it's a 51% sign that says we're a 51% establishment and you cannot bring concealed handguns into this place. So if you go to a bar in the state of Texas, no one can openly carry in a bar in the state of Texas. But if you walk in and there's no sign, there's no 51% sign there, people in that bar can legally be carrying handguns, concealed handguns, if they have a license. You cannot have handguns or long guns at professional sporting events, at correctional facilities, civil commitment facilities, hospitals, or nursing homes but we have the same license holder exception for hospitals or nursing homes, and that is they concealed license holders can have a concealed handgun in in the hospital or the nursing home, unless there's a sign up front saying that this is a gun-free zone. You cannot bring guns in. Mental hospitals, no handguns or long guns. Amusement parks. Amusement parks have the same sign exception. So no long guns or handguns in amusement parks, unless you can have a concealed handgun in a amusement park if you have a license, unless there's a sign at the front of the amusement park. Then there's rooms of open meetings of a governmental entity. So what that means generally is that there can be open carry generally in government buildings, not law enforcement buildings, but in, like, for example, City Hall. Generally, there can be open carry in the City Hall. You go through a metal detector and they'll find it, but then they have to tell you, they come back and tell you, you have the right to carry it, but now they know. And the idea is that the people know that there's someone carrying within the facility. This exception said, well, if there's a meeting going on, a city council meeting, a school board meeting, you cannot bring a gun into the actual room where the meeting's occurring. But the legislature made an exception to that and said that a license holder can bring a concealed handgun into an open meeting. So you could have one of these unbelievably heated school board meetings or city council meetings, and there can be people in those meetings with concealed handguns if they have a license, and they're legally allowed to do that. There's we talk about the laws about open carry, having guns on campuses. This law said that you can carry open guns around a college campus, but you can't take it into a building or into a sporting event over there. So it used to be until 2021 that in Texas having a license was important because you could carry a concealed handgun with the license. 2021 going forward, no need anymore. So why would you still get a license? Well, you get a license for the reasons we just talked about. Those places allow you to carry concealed handguns with a license if there's not the appropriate signage. Sometime for reciprocity. So if you have a concealed handgun in your vehicle or on your person and you're going across state to a state that also allows carry, but it has a license requirement, then the Texas license can have reciprocity for that. A license also allows you to have a gun on school premises, concealed in your vehicle. When picking up your children, you're allowed to have that concealed handgun, and the license allows you to have that. One of the things, and there really is not much of a delay, but in Texas, if you have a license, you've already gone through a background check. So if you go into a federally licensed dealer in Texas and they have to do a background check on you for buying this particular firearm, with a license, they don't have to do the background check because as part of the licensing process, a background check is already done. So it helps you with that. Interestingly, having a license gets you, if you're a golfer, you know what mulligan means. Mulligan means you hit your tee shot and it goes into the water and you're just playing with friends and having fun. And so they say you get one mulligan around, you get to get that free shot without penalty. That's what you get. You get a mulligan at the airport if you have a license in Texas, and that is if you have a gun in your luggage and you accidentally or don't intend to carry the gun, and you're going through the process and the TSA finds your gun. You don't have to go through the whole criminal process right then. If you have a license, you say, I made a mistake. They give you your gun back. You take it off. You go put it away, and then you can go through again. I didn't know that. I think that's pretty interesting. Some other interesting things under the law. When you come to Texas, you don't have to be a Texas resident. You can come to Texas, buy a gun, carry it around. No requirement that you be a Texas resident. You don't have to register it. You come to Texas, buy a gun, put it on your side, don't have to register it, you're fine. there can always, when you're carrying a handgun, you can have one loaded in the chamber ready to go. There's no requirement, nothing that prevents you from doing that. You can carry when you have a mask. There's nothing under the law that requires that under a mask. If you can, in Texas, you've seen it all the time with the rifles and the long guns on the back of the pickup. That is allowed in Texas. You're allowed to carry your long gun in your car. You can also in Texas carry a handgun in a national park. I want to go into another area really quick. It's the castle doctrine in Texas. So the castle doctrine is that when you're in your home, then if someone comes in and tries to rob you, you can defend your home, you can defend the people, you can defend yourself, and you can meet their force. Most of the time under Texas, the way you think about it is force equals force. So if they're coming in to threaten your family, and it looks like you have a reason to believe it's deadly force, or they're coming in for kidnapping or murder or sexual assault or robbery or aggravated robbery, those are different things. If you reasonably believe that's what they're coming to do, you have the right to use deadly force. But if it's just a fight in your house, you can't just a fist fight and you're just in there and a fight breaks out. You can't just pull out a gun and shoot somebody. There's no gun there. There's no reason to believe that there was anything but a fight going on in there. And so you don't need to be doing that. But if you're protecting your house, you're protecting your family, the law allows you in Texas to do that. Also, it talks about you can use reasonable force to prevent arson, burglary, and robbery, especially at night, is what it is. The issue is really what it comes down to is that you as the owner have to show that you reasonably believe that you could not have protected or recovered or protected yourself by any other means, and you believe that these things were going to happen. It really comes down to what you reasonably believed. And you can protect your property that way too. If you reasonably believed that it couldn't be protected by other means, you can protect your property. So in Texas, you don't have a duty to retreat. Generally speaking, you don't have to retreat. That again goes down to the fact of what you reasonably believed. But generally speaking, the castle doctrine works. Now, the castle doctrine also extends to your place of employment and your business. So if you believe any of those acts are about to occur, robbery, murder, sexual assault, and you are in your place of business and someone's coming in to do that, the castle doctrine applies, and you have the right to use the appropriate amount of force. It also extends to any vehicle that you use for transportation. It includes planes, trucks, cars, golf carts, and ATVs. So the castle doctrine applies. If you're in a golf cart and someone's attacking your golf cart, you technically have a reason to protect it. Now, deadly force, probably not, but you can go and use the force that equals force. You can't invoke the castle doctrine if you're the one that provokes it. You can't do that. You also can't invoke the castle doctrine if you are yourself breaking the law at the time. There are some misconceptions with respect to the castle doctrine. You can stand your ground, but standing your ground goes to what force was immediately necessary to protect yourself against the unlawful force of another. So just because someone is about to punch you, you're out in the street, you're not protecting your property, you're not protecting anything else, and someone reaches up and punches you, you do not have the right to pull a gun and shoot them. That's not standing your ground. That is a misconception under Texas law. Force equals force. If you can get into a fight, then you both have assault charges against you. You can deal with that. But you don't have the right to say, "Oh, I'm protecting myself," and shoot him. There's some cases out there that talk a lot about that. You can't shoot someone for getting in your face. If you get in an argument, not everybody, but people get in arguments, and there are time when people get heated and they get in each other's face. If someone's getting in your face, pointing their finger at you, Even saying, I'm going to kill you, generally speaking, I'm going to kill you, I'm coming after you, I'm going to kill you. You can't just pull out a gun and shoot that person right there. That's not allowed under Texas law. Even the threat of I'm going to kill you without any sort of other action to prove that threat with a firearm or with some deadly weapon, there's you don't have the right to go ahead and shoot that person right there. And then you can't set up a condition and say you violated this condition and therefore I had the right to sue you. So you're in a fight with somebody, right? And you're arguing and you're standing there in the middle of, a parking lot and you guys are arguing and the person starts coming towards you and you say, if you get within 3 feet of me, I'm going to shoot you. You cannot preset that condition. And then he gets within 3 feet and you turn around and shoot him. You can't do that. You can't preset a condition and then say, oh, well, he violated this condition I set up. That does not work. Last I want to talk about is civil liability. What kind of liability under firearm laws is there for civil liability? Generally speaking, the way to prove civil liability of who is responsible for a shooting under the law, it really requires to find all the potential parties that are responsible, especially in horrific shootings like the one in Uvalde or the other ones, we've had. I think there was a church shooting that was a couple church shootings that were terrible. It requires a really detailed history of finding everything out about the transaction, tracing the firearm, tracing the individual. It requires you to go through all of it. There was a case in which it was discovered that the individual who bought the gun should not have been allowed to purchase the gun under federal law. It required a very meticulous search to find that information, but when the information was found, ultimately the federal judge in the particular case found that the people who had failed to put the information into the database that would have then been a red flag when someone tried to purchase that particular firearm, they were ultimately liable in that case for that. The lawyers who handled that case on the plaintiff's side did a tremendous amount of work to be able to come up with that conclusion. But that's what it's required in cases, is to go through that. Generally speaking, a manufacturer of a handgun is not liable in any sort of shooting. Really, the only way, again, generally speaking, the only way a manufacturer is found liable is if the gun itself causes injury to the person. So, in terms of themselves. So, if you go to shoot a handgun and it malfunctions because of a manufacturing defect, that's allowed if you get hurt that way. But the gun itself shooting somebody, that is technically not allowed under law. There's a case that came out recently against Remington where they had some liability in a case where the plaintiff's lawyers, it wasn't in Texas, were able to thread the needle. There are exceptions to that rule, but generally that's the rule. Also, under Texas law, there's no civil liability if someone invokes the Castle Doctrine and properly defends themselves. You can't turn around and sue them under civil liability for invoking the Castle Doctrine. We have civil laws that protect them just the last way. Finally, what I'll talk about is negligent entrustment of a handgun. So I had a case in which one of the issues in the case was whether or not the individual who ultimately obtained the handgun, when they stole it, whether or not the person didn't store it properly. So you've got negligent storage of a handgun, and then there's case law about negligent entrustment of a handgun. Negligent entrustment means, like, if you go ahead and let someone borrow your gun, or you entrust your gun to someone else, or somehow consent to them allowing to use your gun, and they go out and do something bad with it, then is there a case in Texas for someone negligently entrusting their handgun to someone else? Believe it or not, this was an open question. It was an open question until 2021. There was a case against a firearm manufacturer, and the Texas Supreme Court decided it in regarding Academy Sporting. It was in 2021. and they generally held what we talked about, that they can't be liable for selling a handgun. But in some comments within that analysis, they talked about negligent entrustment of a firearm in Texas, and it had never been expressly recognized as a cause of action, as a claim that you can bring. But in this particular case, they seem to impliedly say that you could. And then in 2021 in Houston, they cited that Texas Supreme Court, and they said, yes, negligent entrustment of a handgun is a cause of action in the state of Texas. And so, and why is that important? In the cases, it's Dworczyk versus Jones, Dworaczzyk, great spelling, huh? But that particular case said that it recognized a cause of action for negligent entrustment of a handgun. That particular case, though, they said the facts didn't meet negligent entrustment because the individual who did the shooting was an adult in this home with another individual who owned a handgun. The handgun owner kept it under his pillow, and the shooter knew that the owner kept it under his pillow. But the owner never gave permission to the shooter to use the handgun. And on the day of the shooting, the owner said it was probably under his pillow or somewhere in the sheets within his bed, and that the shooter had gone and found it and taken it. And the court said, no, there's no implied consent, no consent there. But had the owner gone ahead and said, yes, you can use my gun, and then the shooter went out and did it, the owner ultimately would have been liable. That's the first two set of cases in Texas law that I have seen that ever held that. And I researched it in my other case. As far as negligent storage of a handgun, I've been unable to find any real cases that talk about that. Again, as I talked in the beginning of this is just a quick overview of some of the laws in the state of Texas with respect to firearms. There's so much more out there. There's so much more I could talk about, but I won't. I just want to educate everybody. Thanks for listening. Have a great week.